So hapa kuna shida kidogo ambapo Ruto's lawyers drop out of Gachagua impeachment case. Yani mawakili wa William Samoei Ruto wao walisema hawawezi wakajihusisha kwenye swala la impeachment ya Rigathi Gachagua au kesi ya impeachment ya Rigathi Gachagua. Okay, kuna watu najua wanajiuliza what happened au ni kitu kipi ambacho kilifanyika mpaka hawa mawakili wa William Samoei Ruto wakaamua kujitoa. Now, President William Ruto's lawyers on Thursday dropped out of the ongoing court case touching on former Deputy President Rigathi Gachagua's impeachment. Iko hivi, while appearing before the three-judge bench consisting of Justices Eric Ogolla, Anthony Mrima, and Frida Mugambi, President Ruto's lawyer Adrian Kamotho Njenga argued that the head of state's appearance was inconsistent with the law. So in his argument, Njenga referenced a previous Supreme Court judgment that ruled that the president could not be enjoined in any legal proceedings such as the one filed by the former deputy president. Sasa hapa tunazungumzia Rigathi Gachagua. Sikiliza vizuri. Njenga informed the court that a notice had already been filed seeking to remove President William Ruto from further participation in the case. Ruto had been listed as the 6th respondent. So hapa haya yalikuwa ni maneno ya Kamotho Njenga. My lord, with your kind permission, I wish to bring to the attention of the court that we shall no longer action for the 6th respondent in this matter, and to that effect, we have filed a notice to cease acting on account of the Supreme Court decision that determined the president cannot be subject to civil proceedings, noted Kamotho Njenga. So in that regard, we will not be able to act contrary to an express court order, and we have therefore filed a notice to cease acting, and we ask the court to deem that to be a sufficient notice that the person named as the 6th person is now not represented in these proceedings. So ukifuatilia vizuri on Tuesday, October 22, the head of state through his lawyers protested the decision by the High Court to hear the case on the impeachment of Rigathi Gachagua. So unajua rais alikataa kupitia mawakili wake kwamba High Court haitakiwi kupewa hiyo nafasi ya kuizungumzia au ya kuiangalia kesi ya impeachment ya Rigathi Gachagua, but I think wao walikuwa wanataka Supreme Court. I don't know the reason why. Wao ndio wanaweza wakajua sababu, lakini kwa upande wangu mimi nikiulizwa nitasema kwamba labda huku chini kuna vitu vingi vinaweza vikafanyika. Siku hizi watu wanalipwa na wanaamua kesi namna ambavyo wao ndio wanataka. So Ruto argued that the High Court had no powers, hawana hiyo nguvu kulingana na Ruto, to hear such a case and that the matter should be a preserve of the Supreme Court. Yani wacha ingie kwa mikono ya Martha Koome. But again, swali ambalo liko hapa katikati ni kwamba kwa nini Ruto anaogopa huko chini na anakubali huko juu? Huku chini kuna namna fulani inaweza ikaegemea upande wa Rigathi Gachagua na sio kwa upande wake. But again, kama anamtambua Martha Koome na Martha Koome ndo kiongozi wa upande huu mwingine, utofauti uko wapi? Sawa, au utofauti uko wapi? Acha tuendelee tu. So the petition hearing filed in this honorable court is clear discard of the laws in misuse of the due process of court, hence cannot be countenanced and determined by this honorable court. Read part of the notice by President Ruto's lawyer to the court. Now, Ruto was forced to intervene after impeached Deputy President Rigathi Gachagua moved to court to stop nominated DP Kithure Kindiki from being sworn in and assuming office. Hapa ilikuwa ni noma. Following the application, High Court Judge Chacha Mwita issued conservatory orders stopping Kithure Kindiki swearing in, but according to Justice Chacha, sasa huyu ni yule judge ambaye alisimamisha swearing in ya Kithure Kindiki. So according to Justice Chacha, the petition raised pertinent constitutional questions that needed to be heard by a bench of judges appointed by Chief Justice Martha Koome. I think kwa upande wao kuna issues nyingi tu ambazo zilikuwa zinamzunguka Rigathi Gachagua, na kwa namna ambavyo wanaielezea hapa ilitakiwa kusikilizwa kwanza na majaji, alafu ndo baadaye kishaisha vitu vinaweza vikasonga mbele. Now, due to the issues raised and the urgency of the matter, a conservatory order is hereby issued staying the implementation of the resolution of the Senate upholding the impeachment charges against the petitioner, reader the court order. So ndo mambo ambayo yanaendelea, mtazamaji wangu. So tunasubiri kuona kama itafaulu hiyo. Unajua nilikuwa nafuatilia and people are like, nyinyi ni muda tu mnapoteza, hakuna kitu kingine hapa kinafanyika. Mtu akasema inaonekana mzee Rigathi Gachagua ana hela nyingi sana. So mambo, kwa sababu mambo ni mengi, ukisikia hata vitu vinaendelea, sio mara lawyers wa Rigathi Gachagua wanataka sio Justice Freda Mugambi yeye atoke kwenye hiyo sio bench kwa sababu sio Kindiki alikuwa ni mwalimu wake. Yani unashangaa sasa akiwa yani yeye Kithure Kindiki kuwa alikuwa mwalimu wa Justice, sasa hawezi akasikiliza kesi ambayo yupo pia around hapa Kithure Kindiki. Hapo ndo kidogo inanishangaza mtazamaji wangu. So mambo ni mengi hapa, so tunasubiri tu kuona kuaje. Acha nikupe hii video uione mwanzo mwisho, lakini ukimaliza hakikisha una subscribe ili uendelee kupata taarifa nyingi na mpya kila wakati. Bye bye.
Good afternoon. Yes, we are now ready for the business of the court this afternoon. We have two applications seeking the recusal of this bench from handling this matter. We have two such applications. One in consolidated petition with file 565, and the other is consolidated petition with file 52. I think because the responses are the same, we will do them separately, but the responses will be the same. So I'll call petition number 5E562. SE regarding Gachagua as the Speaker of the National Assembly. Petition number E565 of 2024.
May I request, with the your kind permission, if we could allocate time so that we structure the presentation. And for our part, the part of the respondents, we will respond together. And whatever time you will allocate to us, we will use together.
For our part, my Lord, because we have to do the job of convincing the court. I believe we agreed for the first application and we the only one deal with it. I believe 30 minutes to present the application.
How much?
30 minutes.
My Lord,
May I call it?
Yes, my Lord, I say that's speaking for myself. I believe the other people will speak for themselves.
my Lord, with your kind permission, for record purposes, I wish to bring to the attention of the court that we shall no longer be acting for the sixth respondent in this matter. And to that effect, we have filed a notice to cease acting on account of the Supreme Court decision that determined that the president cannot be subject to civil proceedings. So in that regard, we will not be able to act contrary to an express court order, and we have therefore filed a notice to cease acting, and we ask the court to deem that to be a sufficient notice that the person named as the sixth respondent is now unrepresented in this proceedings. Thank you, Dr. Kamoto. However, we are not inclined to do anything this afternoon except the business of the two files before the court. After that, we can take directions as may be necessary. Most obliged. As far as time allocation is concerned, this is how we allocate time. The main applicants will give you 15 minutes each. The main applicants, we will give you 15 minutes each. Supporters of the application will give you 5 minutes each. If they are supporting the application, will give you 5 minutes each. Respondents will give you 7 minutes each. Interested parties will give you 5 minutes each. Rejoinder by main applicants will be 7 minutes each. We ask the court assistant to observe time strictly.
Are you permitted to say something?